Folks, I'm going to be going very fast, so bear with me, but I think it'll be a little more interesting if we do that. First principle, first case is the case of Zappiola versus Kordecki. And in that case, the petition for an injunction, protection against domestic violence, was filed in 2016. However, the allegations were that back in 2012, when the parties had a relationship, the respondent punched the petitioner and threw a glass of wine on the petitioner. What precipitated the filing of the petition in 2016 was that the respondent recently had been attempting to contact the petitioner by telephone and Facebook messages. However, there were no allegations that in the phone calls or Facebook messages that there were any threats or anything like that. Long and short of it was the appellate court said that even if back in 2012 the petitioner was punched by the respondent and had a glass of wine thrown on her by the respondent, in the absence of current allegations or allegations of current acts of domestic violence, it's not sufficient for the court to enter an injunction based on allegations or events that happened back some years before the filing of the petition. Certainly, if you look at the statute 74130, you could ask yourself if that really complies with the statute, because what you will not find in 74130 is any sort of statute of limitations. The standard for entry of a final injunction is, has the petitioner been a victim of domestic violence, or does he or she have a reasonable fear that they are in imminent danger of becoming the victim of domestic violence? It doesn't say anything like you have to be the victim of domestic violence within the last 2 or 3 years. However, Zappiola and Kordecki is not the only case that says that, so kind of it doesn't seem like it complies with the statute. Next case is the case of Curl versus Roberts, and in that case, you had a young mother, sought a domestic violence injunction on behalf of her daughter against the child's grandmother. The allegations were that when the young mother was a child, the grandmother abused her, and that abuse allegedly even went into when the young mother became an adult woman. Well, there were no allegations that any events like that happened in the last 2 or 3 years. Also, the petitioner alleged that grandma had gotten involved with the DCF, made allegations against the mother to try to have the child taken away, and I guess grandma got involved in a paternity action. Long and short of it, the appellate court said none of that is sufficient for the court to enter a domestic violence injunction on behalf of the child against the grandmother. There were no allegations whatsoever that the grandmother did anything by way of violence toward the child, and certainly there was no basis to claim that the child was in imminent danger of domestic violence from the grandmother. So that's Curl versus Roberts. Again, I already said that there is a standard. For a final injunction, you have to be the victim of domestic violence or reasonable cause to believe you're in imminent danger of domestic violence. A couple of cases. Next is the case of Hutzel versus Hutzel. And in that case, the parties were married. A few years before the filing, they had purchased an automobile that had the so-called OnStar safety feature. However, when they bought the car, the respondent's email address was apparently the one that was used when the car was purchased to set it all up and arrange it. And apparently the OnStar system had been activated. So the petitioner was concerned that because of the OnStar system, the respondent would in fact be able to track her movements based on receiving data through the OnStar system. She alleged 2 main allegations. Number one, she was at a restaurant, the petitioner was at a restaurant having lunch or dinner with one of the respondent's relatives. The respondent enters the restaurant, sits down, has a meal, had no interaction with the petitioner. The second incident pertained to a text exchange that the parties had, where based on the text messages sent by and between the parties, the petitioner was convinced that the respondent must have been tracking her location, again, through the OnStar system. Appellate court said neither one of those things that the petitioner alleged are sufficient to cause the court to believe she had a reasonable fear that some type of act of domestic violence against her was imminent. Again, that's the Hutzel versus Hutzel case. The next case along the same lines is Tate versus Tate. I call it the Cats case. In that case, you had an adult brother and sister. They were residing together. At some point, they had rescued some cats. So they were living together, had cats in the home that they had rescued together. Either the petitioner wanted the respondent to leave or he left on his own. In any event, he moves out of his sister's home. At some point thereafter, he enters the home and he takes one or more of the cats. There were no threats of any violence made against the petitioner, no actual violence committed by the brother against his sister. He simply went into her home without her permission and took the cats, one or more of the cats. Again, appellate court said that's simply not sufficient for the court to enter a domestic violence injunction. Next is the case of Robinson v. Robinson. And this stands for the basic proposition that uncivil behavior, such as yelling and swearing at someone, is not going to be sufficient for a domestic violence injunction. In this case, the parties were husband and wife. For some reason, they had to meet at a bank. When they were at the bank, the husband was yelling at his wife and using obscenities toward her. There were no threats of any violence, and there was no actual violence committed by him toward her. He also made the allegation, or she made the allegations, that he had threatened to call her HR department, that he had called her work when she was there, and that he had reached out to other family members, such as her parents, brothers, sisters, that sort of thing, to try to get her to talk to them so that they could try to reconcile their marriage. Appellate court said, again, this is simply not sufficient for entry of a domestic violence injunction. Not condoning his behavior, yelling, using profanities in public, probably shouldn't do that, but that's not enough to cause someone to have a reasonable fear they're in imminent danger of domestic violence. Probably should interject, and this will come up later, but remember, and it can be important in these cases, violence has a definition, and that is assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any other criminal offense resulting in physical injury or death. Next case, and this is the case of Counsel v. Anderson, Weiss versus Pettyhome. Do not, as a trial judge, enter a series of temporary injunctions, and make sure when you enter a temporary injunction that you have a final hearing date set in the paperwork. This may come up, maybe you're at a final hearing and maybe you're convinced in your mind that the parties need some space. They need to be apart for 6 months or 3 months, whatever you're thinking in your head. But you also may be thinking something like, if I put some space between the parties, things will simmer down. And maybe you're thinking, I don't want to, if I can avoid it, I don't want to enter a final judgment against the respondent, which certainly is not a plus for that person's future. Having said that, unless the parties were to agree to it, do not enter another temporary injunction or a series of injunctions, temporary injunctions, over objection of a party. Wherever the chips fall, the parties are entitled to a final hearing. That's kind of an interesting case, Taylor versus Price. Now, in that case, what had happened was they're at a final hearing. The lady had alleged a battery committed by her husband upon her. She apparently had bruising in her chest area, and she offered to the trial judge to show the bruise or markings on her body to the judge. Trial court said, no, you don't have to do that. I'm taking your testimony as truth. I'm believing it. She indicated, the trial judge indicated she was taking the wife at her word. There was no contradictory testimony. The wife's testimony was not impeached in any way. Notwithstanding that, the trial court did not enter a final injunction. Appellate court said, yes, the trial court should have entered an injunction because the testimony of the wife on pivotal issues was not contradicted in any way, not impeached. There was no contradictory testimony. And the trier of fact should have taken her statements as proof of the disputed issue, whether in fact there was an act of violence, domestic violence committed by the respondent on the petitioner. Again, that's Taylor versus Price. Next is the procedural thing, kind of a weird one. And this is the case of Porvaznik. I'm sure I mispronounced that one, versus Porvaznik. And in that case, a temporary injunction had been entered. The respondent's attorney filed a motion to dissolve the injunction and obtained a hearing date from the court, set that for hearing. Thereafter, the attorney filed an amended notice of hearing for a different date. Notwithstanding that, the trial court went ahead on the day as originally was set, because the respondent and his attorney showed up for the date originally set. Trial court expressed concern, like, hey, this isn't even on my docket, and I don't think the petitioners had proper notice. Notwithstanding that, court went ahead and conducted the hearing, went ahead and dissolved the injunction. Ultimately, that was reversed by the appellate court because there was no due process afforded to the petitioner, because the court addressed the motion to vacate on a day when it was not actually set for hearing. Next, and this could come up quite a bit, and this following principle applies regardless of which type of injunction you're dealing with. If you get a motion to dissolve or modify an injunction, do not summarily deny it. The respondent is entitled to a hearing. I probably would agree that if the respondent simply does not state a cause of action, does not state any basis upon which you could modify or dissolve the injunction, I might agree at that point that the respondent is not entitled to a hearing. If, for example, the respondent in a motion said, trial judge was asleep at the wheel the day of the final hearing, wasn't paying attention, was staring out the window, whatever. Even if all of that is true, that is not a basis to modify or dissolve the injunction. But assuming the respondent puts in paper something that may entitle him or her to a modification or dissolution of the injunction, do not decide it in your head when you're reading the motion. Just go ahead and grant the motion or set a hearing and then address it at that point. A lot of cases say that, Palm v. Palm, Alston v. Haynes, and again, that's across the board on any of the types of injunctions you may deal with. This kind of ties into the next point. A motion to modify or dissolve an injunction requires a change in circumstances. It's not another bite of the apple simply to convince the trial court that he or she was wrong the first go around. First case is the case of Trice versus Trice, which is kind of interesting. Back in 2011, the parties were married, residing in Tampa, both in the military, maybe at MacDill. Wife announces that she wants a divorce. Husband didn't think too much of that, so when the wife was out in the garage with the child, the husband confronted her, actually pulled a firearm out and threatened to kill the wife. He was charged with, at that point, criminally, and obviously the wife was able to get a final domestic violence injunction, pretty clear at that point. Now fast forward at 6 years later, we're in 2017, Mr. Trice files a motion to modify or dissolve that injunction, and the basis was the following. Number one, the marriage had been dissolved. He was actually acquitted of the criminal charges flowing from when he pulled the gun on his wife in 2011. Parties were divorced. He left the military and moved from Florida to Kansas. She's still in the military, but moved from Florida to Japan. There had been no contact between the parties in the ensuing years between the entry of the injunction, or at least the entry of the divorce decree. No allegations that the respondent had ever violated the injunction. And the respondent also claimed that the final injunction was hurting employment possibilities from him. Appellate court said, yes, the respondent has sufficiently shown a change in circumstances such that continuation of the injunction would serve no valid purpose. That's Trice versus Trice. Now, if you compare that with no versus no, in that case, despite the passage of something like 15 years between the entry of the final injunction and the motion to dissolve the injunction filed by the respondent, despite that passage of time, the appellate court said, no, we are not going to dissolve the injunction. Critically important in that case is Mrs. No, who if she wanted the injunction continued, she had to show the court that she had a reasonable fear of becoming the victim of domestic violence in the future. She was able to convince the court of that. He was not scheduled to be released from prison for 5 more years. He had already been in jail for 5 years. But she testified, and apparently it was accurate, that when the parties were, after the entry of the injunction, but before he became incarcerated, there had been numerous violations of the injunction over the years. And that really seemed to be dispositive to the trial court, or excuse me, appellate court, and that's why the injunction was not dissolved. That's no versus no. Next, as you know, in domestic violence injunctions, we can be called upon to address child support. Next case, Carroll versus Gall. Basically, in that case, trial court set an amount of child support, but I believe the injunction had a set time. I don't remember if it was a year or whatever, but by its own terms, it was going to expire. So the question becomes, if the trial court set child support of, say, $500 per month, but the injunction ends, in 1 year, what happens at the 1 year mark? Where what Carroll versus Gall says is the child support award ends when the injunction ends. The clock does not continue to run, and there's nothing in the law that says child support entered in a domestic violence proceeding has to stay in effect until another proceeding, such as a divorce or paternity action, would pick up the issue of child support. Next, I'm not aware of any case where Chapter 57-105 fees are available in a 740-130 domestic violence injunction case. There's a case of Sager versus Holgren, which was in the first DCA in 2018, and that stands for that proposition. No 57-105 fees in 740-130 domestic violence actions, and I can't find any case since Sager that would contradict that. Next, the case of Youssef versus Saitoni. That case stands for the proposition that you need to have personal jurisdiction over the respondent. And in that case, the parties resided in the state of Ohio. There was a domestic violence incident, apparently took place in Ohio. The lady came down to Ohio with the children. Trial court based its exercise of personal jurisdiction over the respondent on the following factors. Number one, that the respondent had family in Florida. Number two, that the wife and children have came to Florida in the past to visit, vacation, that kind of thing. And lastly, when the petitioner and the kids would come down to Florida, the respondent himself would come down to visit. That is not sufficient under our long-arm statute 48-193 to exercise long-arm jurisdiction over the non-resident respondent. Also, the appellate court or trial court said that there is a safety exception under 48-190 or safety exception for protection of the petitioner. I guess eliminating the requirement to follow 48-193. In any event, the appellate court said that is not a sufficient basis to exercise personal jurisdiction over the respondent. So bottom line is you got to have personal jurisdiction. That's not going to come up very often, but if it does, there you go. Next, another due process case. Now, in this case, the respondent alleged that he was denied due process when, first of all, the petitioner alleged one particular incident in her petition with a set date. This is what happened on that set date. In addition to that, she alleged in general terms that during the marriage, she had been pushed countless times, slapped, pushed, shoved, pinned against the floor, pinned against the walls. Now, there was apparently no dates in the petition. It was probably one of those scenarios where you can check the box saying, he's done these things to me before. Trial court said when the petitioner was allowed to testify about those acts generally alleged in the petition, in addition to the one specific act, that was not a denial of the respondent's due process rights. Obviously, don't forget, if the respondent wants, actually, if either party wants, they can engage in discovery on these things, and the respondent's attorney certainly had an opportunity to set the petitioner down for a deposition to inquire from the petitioner about those other incidents generally referred to. But the general allegations were sufficient. Next is the case of Carrillo v. Carrillo. Maybe there's multiple cases. If you're like me, you have the Unified Family Court, and maybe today you're hearing a domestic violence injunction, but last week you heard some evidence in the party's divorce action. If you are going to use evidence that was presented in a different case, say the divorce case, and that evidence is going to be the basis for your decision in the domestic violence case, go ahead and first use judicial notice and make the evidence from the other case part of the evidence in this case, in your DV case. Then you'll be fine. That's the case of Carrillo v. Carrillo. Next, and this could happen if you are either the judge that has the domestic violence docket, or maybe you're the duty judge. Remember, if you get a petition of any type, you really have three options. Number one, you grant a temporary hearing, set a return date. Option two, you maybe don't grant a temporary injunction, but you think a hearing's in order, so you go ahead and set a hearing. Option three is you outright deny it. Number of cases say Vitale versus Holmes, and one of them is one of the cases. And again, this is across the board, any of the types of injunctions. If you are going to deny it outright without a hearing, put in writing the reasons why you think the petition is legally insufficient. I get that occasionally in the area of repeat violence, where you have to have 2 acts of violence, one in the last 6 months. So say, for example, you have an act of violence, but you only have one, or it's too stale. Just put that in writing as part of your denial. Just don't simply deny it. And again, a lot of cases say that, but the one in the material is Vitale versus Holmes. That's the case of Gonzalez versus Baez. At least for questions of fact, a trial judge's decision is not to be disturbed absent clear abuse of discretion. Witness credibility is obviously, I guess that's like the bottom line as to what's the trial judge's province. But in Gonzalez versus Baez, the respondent did not like the fact that the court entered a final injunction, and basically he took issue with the fact that apparently the trial judge believed the petitioner and her witnesses, did not believe him and his witnesses. Well, that's exactly what trial judges do all the time. That's not going to be sufficient for an appeal. That's Gonzalez, a successful appeal. That's Gonzalez versus Baez. Next, there's the standard. I'm not going to read it as to a final injunction, but I'm going to point out 2 cases, kind of draw the distinction. The first case is Leo versus Rodriguez. And in this case, the guy was a control freak, putting it nicely. What he would do is, when the parties were living together, he would not, quote, not let the petitioner work. He would not let her have friends or have relationships with her family. He tried to isolate her. He would control the petitioner's time and money. When the respondent, quote, finally let the petitioner work, he would accuse her of being somewhere, if she were late, being with someone she shouldn't be with, if she were late. So as I said earlier, kind of a total control freak. He did allege that he hit her in the past, but that had been a little bit before she filed. The final precipitating incident was they were together when they were with their child. They got into an argument about the child's backpack. The petitioner wanted the respondent to pick up the child's backpack because apparently it was heavy. Respondent kind of wigged out on her, ran up to her, started using profanity, saying such things: I'm going to destroy your life. You don't know who the blank you're dealing with. Your mother and father are going to be crying. You're only safe because you're the mother of my son. If you weren't, I would destroy you. Nice guy. Bottom line is, appellate court said at a minimum, the petitioner established that she had a reasonable fear of becoming the victim of domestic violence. Another case, I'm not going to read the facts, but go ahead and read it. The facts are in the material. It's quite lengthy facts, but that's the case of Zarudny versus Zarudny. And if you read those facts, you'll find the appellate court again said the petitioner is able or was able to establish she had a reasonable fear of becoming the imminent danger of becoming the victim of domestic violence. Now contrast Leo Rodriguez and Zarudny versus Zarudny with the case of Douglas v. Douglas. Now in that case, and here's your little phrase from the case, to enter a final injunction, the danger feared has to be imminent and the rationale for the fear has to be objectively reasonable. Now in the Douglas case, what the respondent did was the following. He followed the petitioner to her work. He sat in his car, waited for her to come out of work. She's walking out to her car with coworkers, and he sped off in his car. I don't know, he's like 18 years old or something, but he sped off. Next time, when she came home, another day, she came home, he locked her out of the master bedroom and he wouldn't talk to her. Another time, he was at the same bar she was at for St. Patrick's Day. Apparently, they had no interaction. And lastly, another time, he was at the same shopping center she was at. And apparently, there was no interaction at that point. And lastly, he one time confronted her in the home. She was not wearing her wedding ring, and she apparently did not attend one of their children's events. I don't remember if it was a baseball game that their child had, but she wasn't there. So he confronted her. He was very close to her. He was yelling at her. No violence, no threats of violence. He was just shooting off his mouth, plus the other stuff I said. Appellate court said that is not being simply sufficient with what Mr. Douglas did for the court to enter a final injunction for protection against domestic violence. So contrast Leo Rodriguez, Zarudny, and the Douglas case. Next, pretty obvious, if you're going to enter a final injunction, you got to have an evidentiary basis to do that. In the Newsom case, what had happened, petitioner shows up, respondent's counsel did not show, or respondent's counsel showed up, respondent was not there. Respondent's counsel asked for a continuance, that was denied. Trial court then says to the petitioner, do you want the injunction? And petitioner right on cue says, sure, I'll take that injunction. And ultimately the appellate court said, number one, the respondent was denied due process. I don't know how the court really came to that because he was served, he just wasn't there. But more importantly, that there needs to be an evidentiary basis. So the petitioner simply saying, yes, I want the injunction is not enough. If the trial court was going to go ahead that day and deny the continuance, which it did, it should have went ahead and conducted the hearing and make petitioner testify as to what happened. And then the respondent's counsel could have at least cross-examined, or in that case is Newsom v. Newsom. Next, this is the case of Smith versus Daniel. You had a Kentucky final injunction. That injunction actually prohibited the respondent from being within 500 feet of the child. So, pretty serious stuff. Parties somehow were down here. Florida court enters a dissolution of marriage action, a judgment. The judgment entered by the trial court down in Florida provided for the respondent to have supervised time sharing with the child. Ultimately, the appellate court remanded it to the trial court and basically said trial court needs to make further findings of fact under 6113 and also under the Kentucky order of protection, because apparently the appellate court was concerned that with such clear findings of fact in the DV case from Kentucky, the trial court in Florida did not give it the due that it was entitled to, and just, I guess, apparently made cursory comments about it. But in any event, if you have a foreign domestic violence injunction, it is entitled to full faith and credit in Florida. That's Smith versus Daniel. Next, the bane of our existence, stalking injunctions. I'm just going to briefly say the statute. Obviously, everybody can read. It's willfully, maliciously, and repeatedly following, harassing, or cyber stalking another individual. We love definitions. Harassment is a course of conduct directed at a specific person, causing substantial emotional distress and serving no legitimate purpose. Those prongs are important. You'll find a lot of cases, the substantial emotional distress prong falls short. Course of conduct, pretty simple. engaging in a series of acts or a course of conduct over time, however short, which evidences a continuity of purpose. And lastly, cyber stalking, pretty much you can read it. A course of conduct directed at a specific person using or engaging in a course of conduct to communicate or cause to be communicated by electronic mail or electronic equipment, words, images, or language. Again, directed at a specific person, substantial emotional distress, and serving no legitimate purpose. Now, recently, the second slide here, I'm not going to read it, but that little, I'll call it a clause, is an addition to the definition of cyber stalking. And again, it has to be directed at a specific person, causing substantial emotional distress, serving no legitimate purpose. And this basically, someone without permission is accessing online accounts or internet connected home electronic systems of another person. You'll see that definition of stalking at 748.0485. The cause of action is 784.0485. Next, kind of a weird case, the case of Neal or O'Neill versus Goodwin. Remember the definition? Well, in this case, the parties had a relationship, they broke up. After they broke up, the respondent goes to film school. That's interesting. He goes to film school, graduates from film school, and ultimately he contacts the petitioner and says, look, I am going to be making a documentary film about you. Would not be flattering. And I have access to Instagram photos that will be part of the documentary. And apparently she was dating some new guy and he was going to be part of the documentary. Appellate court ultimately said that the respondent had a legitimate reason for contacting the petitioner other than to harass her, and that was to let her know that she would be featured in this documentary. So no stalking injunction. Next, pretty obvious, well, maybe not obvious, but we judge whether conduct is going to cause a substantial emotional distress by a reasonable person standard. In the case of David versus Schock, in that case, apparently, the respondent knocked on the petitioner's door, left her a note, and left her a check. That's all he did. Appellate court said that is simply not conduct that is going to cause a reasonable person substantial emotional distress. Next, and that's the fourth DCA. Take a look at the case of Pickett versus Copeland, which is a case out of the first DCA. And I'm going to ask you to read that case if you're interested, because it has a very good discussion of stalking and some case law. And you'll see that apparently the first DCA, Pickett Copeland, and the fourth DCA take a different approach. The first DCA, which I think is the more accurate interpretation, says, although stalking by definition requires repeated acts, it only takes one act of stalking, if proven, to entitle a petitioner to a final injunction. The fourth DCA in the David versus Schock and those like cases seem to be saying that not only do you have stalking requiring multiple acts, but in fact, you have to have multiple acts of stalking. Again, all I'm going to say to you is I think Pickett Copeland is right. Read Pickett Copeland has a great history of case law and statute, but apparently, from what I can tell, there's a disparity or difference in the way the first and the fourth treat the issue. Next, an injunction, even if you're going to enter it, should never be broader than is necessary to protect the petitioner. In the case of Smith versus Weicker, the court went ahead and entered a final injunction for protection against stalking, but actually put in the injunction the respondent is enjoined from lingering in his driveway. Problem with that is it could enjoin conduct that is perfectly acceptable in addition to conduct that could constitute stalking. So that's simply too broad, and it was remanded to the trial court to correct that. Next, the case where the appellate court said, look, at a minimum, this lady's entitled to a hearing. This is the case of Five versus Bennett. The parties were in a relationship in 2014. Respondent at that point was working for the petitioner. The relationship broke up. Big surprise, his employment was terminated. Thereafter, he started to harass the petitioner and her employees by a series of threatening phone calls and going to job sites. He ultimately had charges pressed against him for making threatening phone calls. And in fact, he entered a guilty plea to 2 counts of making threatening phone calls. And as part of his terms of probation, in the criminal case, he agreed that he would cooperate with the petitioner for her to get a final injunction for protection against stalking. Apparently, her petition was denied when she filed it. It was appealed. The trial court said, look, at a minimum, this lady is entitled to a hearing based on what was in her petition. That's 5 versus Bennett. That's kind of an interesting case, and frankly, one that comes up a lot more now, and it will continue, is the case of Scott versus Blum. In that case, the parties, a couple of guys, were members of a business organization. The respondent began to disseminate emails about the petitioner, about the petitioner's family, and about his colleagues, his associates, to other members of the organization. These emails simply were not very flattering. They apparently were derogatory. The petitioner testified that they were causing him emotional problems. He was having trouble sleeping, that sort of thing. The emails were not sent to the petitioner directly by the respondent. Apparently, he found out about them by people calling him and saying, hey, look, you see what this guy sent me? So other people would call him and tell him about them, or they would actually forward the emails to the petitioner. But at no time did the respondent actually send these to the petitioner. Long and short of it, appellate court said this is not cyber stalking. There were no threats in enoemails, but the appellate court said, look, comments made on electronic medium that are designed to be read by others, third parties, that is, they are not directed to a particular person and are not cyber stalking. I mean, maybe the petitioner would have a cause of action for defamation, but it is simply not the stuff of which cyber stalking injunctions are made of. That's Scott versus Blum. Another case where an injunction was too broad, this is David versus Textor, and in that case, the injunction actually prohibited communication by the respondent, not only to the petitioner, but about the petitioner. The about the petitioner is too broad. It violates the respondent's First Amendment rights. So it was simply too broad. It was remanded to the trial court. That's David versus Textor. Next, a kind of an interesting case. This is the case of Rawlerson versus Font. Now, in this case, you had 2 attorneys that, quite frankly, didn't like each other. They had been adversaries in a number of lawsuits. So the respondent engages in the following acts toward the petitioner. Number 1, he would tell her he's going to do what it takes to ruin her reputation and cause her to lose her law license. He told her he was having her followed by the use of drones. He apparently was making sexual advances toward her, and within earshot of her, he would ask other attorneys if those attorneys were having sexual relations with the petitioner. It's not even enough for this guy. He goes even further, and he would actually subpoena the petitioner to attend hearings that would have nothing to do with her or any of her clients. Long and short of it said, the appellate court said the core allegations did not amount to harassment under the stalking statute, and the things that are alleged to have been done by the respondent attorney are best addressed in Florida bar disciplinary proceedings. I don't know what happened after that, if the bar took the respondent to task for that, but no injunction for that, Ms. Rawlerson or Ms. Rawlerson. All right, next there's a series of cases. I'm really only going to talk about 2. But as you know, if you do this docket, what do you get every docket? Stalking injunctions dealing with neighbors. And the first case is the case of Paulson versus Reinhardt. And in that case, Parties were neighbors. First thing happens, respondent comes over to the petitioner's home and says, hey, look, lady, can you turn off your light that you have on? She had it on for security, but it's shining in my house. Can you turn it off? She says, sure, I'll do that. She turns it off. Some days later or so, she turns it back on. He ultimately comes back over and says, hey, lady, can you build a box or something around that light because it's continuing to shine in my house. Thereafter, he began to call authorities in the community complaining about her dogs barking and the continual light problem. What actually apparently brought it to a head is they lived near the ocean. And she alleged that when she would sunbathe on her deck, the respondent would be on a small deck that he had so he could stare at her, even though he had a nice large deck on the other side of the house, which apparently had a view of the ocean. But in her mind, I guess he was using the small deck just so he could stare at her sunbathing. Respondent basically says, look, I don't want anything to do with this woman. Yes, I'm the one that complained. Yeah, I complained about the lights. I complained about the dogs, but it had nothing to do with her. I would have complained about anybody doing that kind of thing, kind of like he's the cranky neighbor that you all hope you don't have. In any event, the appellate court said the conduct complained of is not going to cause a reasonable person substantial emotional distress. And going back to the Scott Blum case, that's the one with the emails to other business members. Again, appellate court said in that case, conduct is not going to cause substantial emotional distress to a reasonable person. Another case that kind of stands for the same proposition. I'm not going to read all the facts. Again, the case of Caterino versus Torello has a long fact pattern. But that case, again, neighbors, no injunction. Take a look at the case of Shannon versus Smith. In that case, you had neighbors. The respondent was doing such things as chasing the petitioner down a sidewalk, yelling at the respondent. There was a lawsuit in the community in which the petitioner apparently was a participant, and there were signs in the neighborhood about the lawsuit. The respondent apparently would tear down the signs at different times. Appellate court seemed to think that these things that allegedly were done by the respondent were petty and are simply not going to cause a reasonable person substantial emotional distress. Next, another case where you have too broad of injunction. This is Givens versus Home. The injunction it was entered kind of a standard default provision, 500 feet. The respondent could not come within 500 feet of the petitioner's home. Problem was the homes were only 90 feet apart. Case was remanded to the trial court to change the buffer zone because at 500 feet, the respondent would have been deprived of the lawful use of his property. So the court needed to revisit that and just simply tailor the buffer zone to what in actuality the distance the parties were apart. That's Givens versus Home. Next, kind of an interesting case, pretty recent case of Logue versus Book. I'm not going to read all the facts, but basically the petitioner was a public advocate for child abuse victims, and she promoted strict sex offender laws. The respondent was an outspoken critic of sex offender laws. So they didn't see eye to eye on that topic, obviously. And apparently they would run into each other at various speaking events. And there's a couple mentioned in the facts, which I'm not going to read. Where I want you to hone in on is the social media aspect of the petitioner's complaint. Apparently, the respondent had many social media blogs, and he would post a lot of negative, nasty things about the petitioner. They're set forth in the facts. These posts were not directly transmitted by the respondent to the petitioner. Apparently, in some of his posts, there was a song and a video that were vulgar and had obscenities. There was a cartoon posted by the respondent about the petitioner, which the appellate court characterized as an intense expression of ill will toward the petitioner. So a lot of negative things, and maybe, again, maybe subject to a defamation suit. But here's your little phrase from the case. The courts have kind of exempted a, quote, course of conduct directed at a particular person to exempt social media messages that are not directly sent to the petitioner, even if they are offensive or vulgar. Again, he's blasting away in social media about the petitioner, a lot of nasty things, but they were not sent to the petitioner. So read Logue versus Book. And that kind of stuff is, I think, is only going to come up more and more because so many people live on social media. Next, and I'm not even going to get into the facts, but again, a neighbor case, these stalking injunctions are simply not to be used to keep the peace between neighbors. They're simply not. Take a look at the case of Carter versus Malkin. Again, simply not sufficient for a stalking injunction. Next, a case where the respondent was denied due process because he was not allowed to introduce text messages or call a witness to testify. The text messages aspect is important. Remember, did he have a legitimate purpose for contacting the petitioner? He wanted to show the court he had a legitimate reason for contacting her, and that was to see if she had lapsed into substance abuse. Apparently they had a relationship in the past. So he wanted to show the court he had a well-meaning fear or well-meaning concern that she actually had lapsed into substance abuse. And he wanted to show the court, hey, these text messages will show you. That's what I wanted. That's what I was inquiring about. Trial court wouldn't look at them. Trial court should have looked at them. That's Ceylon versus Grant. Next, Burns versus Baccarat, pretty obvious. You need to have an evidentiary basis to enter an injunction. And in that case, everybody was at the hearing. The respondent said, tells the petitioner's attorney, apparently, look, I'll stay away from her. But there was no stipulation to a stalking injunction and no stipulation by the respondent that he committed acts that would meet the definition of stalking. Trial court went ahead and entered the injunction. Respondent files motion for rehearing. Trial court denies that. In any event, the trial court, the appellate court reversed, saying that there needs to be an evidentiary basis, and simply saying I'll stay away from her was not enough. Kind of the same thing. You need evidence. You need some kind of evidence. As what's the phrase? Competent, substantial evidence to justify a stalking injunction. If you take a look at Reed versus Saunders, they're at the final hearing. The petitioner apparently tells the court, I have, Judge, she's been contacting me by email and by text constantly. And that was okay, except there was no evidence that the trial court, number one, took these emails or texts into evidence, and there was no evidence that the petitioner even showed them to the trial court. So the trial judge did not look at the text. Without doing, though, there would be no basis for the trial court to know what, in fact, these text messages say. Were they threatening? What did they say? Did they appear to have a legitimate reason for the contact? Would they cause a reasonable person substantial emotional distress? Long and short of it, there needs to be an evidentiary basis. Trial court should have, at a minimum, should have looked at, maybe read into evidence, the text messages. Next, kind of an interesting case, Dixon v. Sermon. Remember, harassment needs to be directed at a particular person. In this case, the Dixon case, husband had a wife and a girlfriend. Apparently, the mistress would come over to the husband's house while the wife was there, would engage in arguments with the husband. No surprise, wife didn't like that. Wife went ahead and obtained a stalking injunction against the mistress. That should not have been entered because the mistress's actions, coming over and arguing with the husband, not directed to the petitioner, not directed to the wife. Kind of a flip of that is Ashford Cooper versus Ruff. And in that case, and husband had a wife, but he also had a girlfriend. And in that case, the wife would be contacting the mistress's home because she wanted to get in touch with her husband. The mistress went ahead and sought a stalking injunction against the wife for contacting her so many times by phone. Trial court said, that's crazy. Those phone calls would not cause a reasonable person substantial emotional distress. That's that case. We already covered that. Next case, McCaffrey-Ashley. This is a case where the appellate court said that the petitioner at least is entitled to a hearing. The parties were former co-workers. In the span of about a few days, the respondent had sent to the petitioner about 160 photos and messages that the petitioner characterized as graphic, obscene sexual statements. He had sent videos. She asked him to stop. Apparently, she put in her petition that these were making her feel very uncomfortable and unsafe. It was like 160 texts and messages and pictures over a few days. Appellate court said, at a minimum, that lady's entitled to a hearing, which initially she was denied. Read the case of Venn versus Falkless. That case simply, and it's right in the case, substantial emotional distress is greater than ordinary distress. It's not enough that something is an irritant, a pain in the backside. A lot of the stuff is, and you may say to yourself, I wouldn't want this stuff happening to me, but it has to cause substantial emotional distress. And Venn versus Falkless, that's greater than ordinary distress, and a reasonable person is not going to suffer substantial emotional distress lightly. Read the case of Klen versus Ransom. In that case, the parties were co-workers, and basically the respondent engaged in a series of actions to hit on the petitioner. He would make comments about her clothing, about her body. He would ask her to go out to lunch. He looked through her cell phone. She felt uncomfortable. She said she felt weirded out by his actions. Apparently, he didn't make any threats to her, and he didn't touch her in any unwanted way. He was just making advances toward her that she apparently had no interest in. She even went to her HR department to rat him out a couple of times. So bottom line is maybe the company she works for is getting ready to write her a couple of checks, but it is not going to justify a stalking injunction. Garcia versus State is simply a procedural thing. I'm not even going to get into that, but it's pretty obvious if you read it. There was a violation of a temporary injunction, which under the facts of that case was still in effect when it was violated, even though a final judgment had already been entered. Next, repeat violence. Remember, you got to have violence, same definition as I went before. You got to have 2 acts, one of which is in the last 6 months. The definition of violence is very important. If you read the case of Tash versus Rogers, you'll see there was only 1 act of violence, and that was a battery. The other stuff that the respondent was alleged to have done, saying to the kid, the petitioner's children, you're weird, or your parents are weird, that's why you're weird. Mumbling under his breath, I'm going to kill you, with no overt act. That doesn't constitute an assault. So you had 1 act of violence, that was the battery when the respondent spit on the petitioner. Not enough, you got to have 2 acts of violence. Next, and I'm going to mention it, I'm going to skip ahead because I noticed I'm way behind on my time. If you look at the case of Hall versus Lopez, a Supreme Court case, Chapter 57-105, fees are available in repeat dating and sexual violence injunctions. I'm going to skip the dating violence because it's kind of a weird statute. First, to get a dating violence injunction under the statute, you got to have a dating relationship within the last 6 months. That has to be characterized by the expectation of sexual involvement or at a minimum affection, and basically it has to be a fairly continuous relationship. So that's the right kind of relationship. Then you've got to show you've been the victim of dating violence and you have reasonable cause to believe you're in imminent danger of becoming the victim of another act of dating violence, or you have a reasonable cause to believe you're in imminent danger of becoming the victim of an act of dating violence. Again, violence for this statute, same definition as before. That's a nice way of saying you can become the victim or be the victim of an act of dating violence unless you can establish prong number 2, you're not getting your injunction. It's that simple. Take a look at the case of Alderman versus Thomas, there was no question there was one act of violence. After that, no contact by the respondent. Petitioner could not establish she had a reasonable cause to believe she's in imminent danger of domestic violence. Take a look at the case of DiStefano versus Long. That's the same kind of principle. In that case, there was a one act of violence. Again, petitioner couldn't show reasonable cause to believe that she would have a reasonable cause to believe she's in imminent danger of another act of dating violence. If you take a look at the case of Sumners versus Thompson, take a look at that case, because in that case, the court did not enter an injunction, but the issue was whether they had the right kind of relationship, and appellate court said they did. The respondent argued that, hey, we didn't date in the sense that term is used. We simply would hook up periodically to have sex. Okay. Appellate court said you engage in sexual relations periodically over time. That's good enough. Although we're not going to enter the injunction, the relationship was satisfactory. Lastly, I'm only going to say on the sexual violence, they don't come up very much, but the main point there is you have to report it if you claim to be a victim, and cooperate with law enforcement, or the respondent has already been sentenced to it, or his or her term of imprisonment is going to expire within 90 days of the date of the filing of the petition. I guess I'm going to stop there. I did put on the presentation, the last slide has my email. If you want to email me anything, that would be fine. Any questions? Because I know, obviously read the cases if you're going to rely on them in court, but I tried to hit what I thought the big ones were. So I guess that's all I have to say, unless anybody has any questions that I can answer in a minute.
Okay, it does look like we have something here from Alice Blackwell. I understand that a motion to modify or dissolve requires a change in circumstances, but since we make temporary orders on time sharing, are changed circumstances necessary to seek modification of time sharing or other temporary relief contained within the final injunction? And I'm not sure, is that, understand that, or you need me to read it again?
I don't have any authority by way of a case of what I'm going to say, but a temporary time sharing order is not subject to the change in circumstances and can be changed at any time. And I'm going to go out on a limb and say, you can go ahead in a DV proceeding at a subsequent hearing and maybe change the time sharing, regardless of whether you have a change in circumstances, because otherwise you'd be in effect changing the law on time sharing, because the case law on the time sharing is about 4 miles long, that you don't need change in circumstances to change an interlocutory order. No authority for what I just said, but I think that's right.
Okay, and the next question is from Cynthia Cox. It says, are the names of the cases and or other materials somewhere else? All I can see is the PowerPoint with no case names. And I do know.
Okay. Oh yeah, I'm sorry. I don't know if the case, I did send to Oscar the all my case law. It's about 25 pages. Obviously, everybody's entitled to that. And if you want it and can't get it any other way, I'll just forward it to you if you just give me your email. Yeah, you got to have all these cases for sure to make Heidner, whatever the phrase is, out of what I said.
And I think Susan mentioned something about sending them out to the emails that we have registered.
Yeah, if anybody wants it, Susan can disseminate it, or just let me know and I'll just fire away. It's no problem.
Okay, please remember to submit. We only have a few minutes left, but I did want to say that the last statement here is from Carol Kelly, who says, great job, Tom. You are wonderful. Thank you.
Thank you very much, Judge.
And I believe that's it.
All right, thank you, everybody. Everybody have a good day.